Queen and Mackinlay and others.
Before we begin, I must explain something. This is a criminal case in which any trial has yet to begin, and no one knows what the evidence will be, still less what facts will be established. A question has arisen in the case which needs to be decided before the proceedings can continue. We are, of course, sitting in open court as usual. However, an Act of Parliament automatically prevents the publication of pre-trial proceedings until after the trial, except for the barest of details, names, addresses, and the offences alleged. The aim is to ensure that the jury is not at risk of being affected by anything published. Publicity could make the trial unfair or mean that the trial could not take place because the defendants have been prejudiced by the publicity. It follows that unless and until the prohibition is lifted, in whole or in part, we cannot follow our usual practice of live streaming the hearing this morning. But it will be recorded for future reference. So we shall first hear argument about whether the prohibition should be lifted, and if so, how and when. And we shall then proceed on the basis of how we decide that issue to hear the appeal. The restrictions will, in any event, last only until the end of the trial or further order. They will not be permanent. Thank you. Mr. Hudson.
My lady,
the live streaming should now be turned off. Thank you.
My lady, my lords, I appear on behalf of the media applicants who are as follows: Channel 4 News, Associated Newspapers Limited, News Group Newspapers Limited, Times Newspapers Limited, and Sky. The parties to the appeal are represented as follows.
Well, we know the answer to that. And Mr. Hudson, you have
grateful.
10 minutes, so you'd better not waste time on things we already know.
I'll be super quick.
Yes.
But may I at the outset thank the court for giving us this opportunity at such short notice to make this application. The application, as the court is aware, is for an order under section 37(5) of the Criminal Procedure and Investigations Act 1996, that those reporting restrictions which are automatically imposed on this hearing shall not apply. My lady, my lords, the position of the parties, as we understand it, is as follows. The Crown, the appellant, see no need to vary the default position, but as far as I'm aware, aren't proposing to make any submissions this morning. The position of the respondents, which is particularly important, is that they are all neutral. Now, as we understand it, that means that none of the respondents, the accused, object to this application, which has implications under the statute.
Yes, we understand those.
And the Electoral Commission are also neutral. My lady, there's a skeleton argument which I know the court has seen, and a small bundle of authorities which I probably won't need to refer the court to, but it's there just in case we need to. The grounds we've set out in the skeleton argument at paragraph 4, page 2, but I can encapsulate those grounds as follows. We suggest, on our understanding of the issues in this appeal, that there is no realistic prospect that a future trial of the accused might be prejudiced in any way by the removal of the reporting restrictions which automatically apply, and therefore, consonant with the principle of open justice, those restrictions ought to be lifted. Now, I say two things about the issue on the appeal and the material facts. The issue on appeal is, as the court is aware and seems to us, a pure question of statutory construction. It's set out on this court's website. I don't need to read that out, other than to make the point it is simply and purely about the way in which election expenses have to be declared and precisely what the relevant sections require. The material facts, which are also summarised on this website, on the court's website, are, it seems to us, not remotely controversial, and those are facts which the jury will undoubtedly be made aware of, amongst many other facts, during the course of the criminal trial, if and when that takes place. So, my lady, my lords, I can summarise our submissions in the following points, and we say it is particularly straightforward. Of course, we would say that, but it is particularly straightforward because none of the accused object to this application. The first point we make is, I've already said, the issue on appeal involves a pure question of statutory construction. Secondly, we submit that, as recognised by the Court of Appeal, is a matter of significant public importance. Thirdly, that issue, the question of construction, is not an issue which will be either considered or decided by the jury. Fourthly, this court will not have to consider, as far as we are aware, or make any observations on the evidence or any factual issues which will have to be considered or determined by the jury at trial. Fifthly, and as a result of those previous matters, the publication of a fair and accurate report of this appeal hearing cannot, it seems to us, create a risk of prejudice, whether substantial or at all, or undermine the fairness of any criminal trial of the defendants. And to the extent that we need to rely on this, that position is reinforced, we say, by the repeated recognition by the courts of the robustness of jurors and their ability to follow directions of the trial judge and to disregard extraneous material. Sixthly, we say, therefore, the principle of open justice ought to prevail and the restrictions ought to be lifted. Seventhly, the requirement in section 37(7) of the 96 Act that this court shall lift the reporting restrictions if and only if it is satisfied that it is in the interest of justice, does not in fact apply on this application, because none of the accused objects to the making of the order under section 37(5), lifting the reporting restrictions. So that isn't the right test. However, even if that were the right test, we still maintain it is clearly in the interest of justice, as that phrase is properly understood, to lift these restrictions. My lady, my lords, I proposed, if necessary, and maybe I can stop at that point and sit down or answer any questions or see if anybody else has anything to say as to why those submissions are incorrect. But I can, if necessary, go through more detail section 37, what we say the appropriate test is, the test for postponement orders under section 4.2 of the Contempt of Court Act 1981, which we say is probably the test that ought to be applied by this court, rather than the interest of justice test on this occasion, and then make good by reference to one authority the point I've made on robustness of jurors.
Yes.
Unless the court wishes me to take up time with those matters, I'm not sure there's a huge amount more I can say other than the points I've already summarised as to why the restriction ought to be lifted.
Well, that's very helpful, Mr. Hudson. I don't know if my lords have any questions.
Am I right, Mr. Hudson, in thinking that whilst, as you rightly say, I'm looking at 6.2 of your helpful skeleton. Obviously, the classic case where there's a danger is the case where the proceedings are going to involve discussion of material that may not be before the jury. Am I right in thinking, though, that's not the only consideration? There may be a risk, may there, or I'll ask the question, may there be a risk simply from advanced discussion of one side of the case?
Of the merits of one side of the case?
Well, simply advanced discussion, advanced publicity of the detail of the case against people.
Well, Lord, I would certainly accept if there was discussion, consideration, and possibly even opinion expressed on the merits of one side's case, then that could potentially prejudice a jury.
Or assertions of fact which may or may not, in the end, be proved.
Yeah, possibly. My only hesitation, if I may, and caveat to that, is this. If the Crown advance a position, which we all know they are going to advance before the jury, and if the court doesn't express any opinion on the strengths or weaknesses of that, then it is difficult to see, we suggest, in that situation, why that would prejudice a jury, particularly when a trial in this case may not take place for 6 or 12 months' time.
Rather different, you see, hearing the Crown open the case and then hearing the judge say, now wait and see, from hearing the Crown's case advanced in banner headlines. It's a very interesting topic.
It is.
Some months ahead of the trial. Anyway, that's all I wanted to ask you.
My Lord, I can see that, and obviously that's a matter the court would have to consider on the facts of each case.
And it would depend, presumably, on what in the end transpired today.
Yes, and this court can, of course, if appropriate, make orders under Section 4.2 of the Contempt of Court Act 1981, postponing the publication of reports of any particular matters. So if during the course of the hearing it suddenly becomes apparent to one of the parties or to the court that a matter needs to be dealt with, that might prejudice a jury in the future.
The problem that we have in this court, uniquely, is that our proceedings are routinely live streamed.
Yes, of course.
Which is why I drew attention to the live streaming and the fact that it's now turned off for the purpose of this hearing, and then unless we lift the restrictions, it will be for the purpose of the whole of today's proceedings. That introduces a dimension which it's much harder to cure retrospectively.
Yes, I recognise that, but obviously on this appeal or this hearing, and no doubt the vast majority of the hearings before this court, the court is dealing with extremely experienced counsel. If anybody felt remotely there might be a danger or a problem, they can, of course, raise that with the court in advance. If necessary, the streaming could be stopped at that point, and the appropriate order, if necessary, could be made.
It's not that simple.
Well, I fear my technical
I wish that
ignorance.
it were, but it's not that simple.
My lady doesn't have a red button.
No, if I did, that would be, especially if my lord had a red button.
I'd have gone through the floor by now.
If we had 5, you'd be in real trouble.
Yeah.
But
That is one of the problems.
Yes.
Of course, the other point to make is that if at the end of today's proceedings we reflect on what you have said and what has taken place at the end of today's proceedings, well, then we can reconsider.
My lady, yes, certainly my clients were hoping the court would reach a decision before the appeal proper starts.
Oh, we will certainly reach a decision about what we'll do during today's proceedings. We will certainly do that.
Yes.
But I'm merely making the point that it's at almost any stage, while the case is still with us, that we could reach a conclusion that it would be in the interest of justice to use it.
My lady,
to lift
of course.
the restrictions, either at the end of today or after reflection on what's taken place today, or when we give judgment, or whatever.
We entirely recognise that, as happens in every criminal court every day. Should a postponement order be made? Should the court sit in private? And that happens all the time, and we recognise that.
No question of the court sitting in private, Mr. Hudson.
Of course.
Your reporters can be here all day, whatever happens. They can write as many notes as they like. The question is what use they can make of them and when.
And also, it's certainly important to my clients as well that the hearing is live streamed in the usual way, subject to any need for interruption to that if it arises. But the fact that none of the accused object, and the position of the Crown, albeit not neutral, seems to be very muted, if I may say that, does rather suggest that there aren't any concerns here about prejudicing the trial whenever that will take place.
Well, we've taken all that on board, so thank you very much.
Is there anything I can assist the court with?
I think not. Thank you very much, Mr. Hudson. Is there anything that the prosecution would like to say?
My lady, the only matter which I ought to mention is this. Having the burden of opening the case to the court, it appears likely that inevitably there will be some reference to some of the facts which are alleged against these prospective defendants.
Yeah. Thank you. Do any of the defendants wish to make any observations? We note your neutrality and we know the legal consequence of your neutrality, and the intervener is also neutral. Well, we will adjourn.
Hearing in the Queen and Mackinlay and others.
Well, we are grateful for Mr. Hudson's forceful and economical submissions in support of the media's application, but we have decided not to lift or modify the reporting restrictions for the time being. I should therefore repeat the explanation of those restrictions at the outset of the substantive hearing. This is a criminal case in which any trial has yet to begin, and no one knows what the evidence will be, still less what facts will be established. A point of law has arisen in the case which needs to be decided before the proceedings can continue. We are, of course, sitting in open court as usual. However, an Act of Parliament automatically prevents the publication of pre-trial proceedings until after the trial, except for the barest of details. The aim is to ensure that the jury is not at risk of being affected by anything published. Publicity could make the trial unfair or mean that the trial could not take place because the defendants have been prejudiced by the publicity. It follows that, unless and until the prohibition is lifted or modified, we cannot follow our usual practice of live streaming the hearing, and nothing may be reported save for those brief permitted details. But the proceedings will be recorded for future reference. In any event, the restrictions will last only until the end of any trial or further order, and they may possibly be lifted before then. They will not be permanent. Thank you.
My lady, my lords, I trust I won't be thought rude if I simply say that all the appearances are as recorded.
You won't. We'll be most grateful to you.
My lady, I also would wish to take, if I may, everything as read, and I'm not, save for observing now that this is in form a rolled up hearing, going to mention the question of permission again. There are three principal reasons we say why the Court of Appeal and the respondents are wrong. The first is an overarching reason, and it is that the language used, that is to say, the language of 90C and 90ZA of the Representation of the People Act, does not permit the outcome settled upon by the Court of Appeal. The true construction reveals a deeming provision with a demand that a particular consequence should follow. And we observe that it is quite difficult to identify a circumstance on the respondent's case and on the matter as put by the Court of Appeal where 90C would operate. Second, we submit that there has been a clear misunderstanding of the purpose of 90ZA4. It is not part of the definition of election expenses. It is simply an elaboration subject to the deemed position of how election expenses by or on behalf of a candidate are incurred, and that is necessary to be known for a variety of reasons as identified in the legislation, not least because the return, section 81, is of all election expenses incurred by or on behalf of the candidate. So one needs to know what that expression means. Third, we say that the Court of Appeal and the respondents have misunderstood the approach of the Representation of the People Act to expenses and have failed to understand that it stands alone in relation to candidates' expenses and prior to party expenses, both historically and as a matter of process under present-day electoral law. Now, the overarching submission, of course, touches upon the question of construction and the meaning of section 90C, and I'd like, if I may, to introduce that by reference to the Court of Appeal's judgment at page 129. The page numbers I give are referable to the memory stick page number, and paragraph 30 of the judgment of the Court of Appeal. And paragraph 30 of the judgment of the Court of Appeal, particularly when one looks at the opening sentences of that paragraph, appear to suggest that control prior to amendment, prior to the amendment which introduced section 90C, was less than after amendment. But that is not so. The Victorian system for election expenses found expression in sections 72 to 90 of the Representation of the People Act 1983 as enacted. And the court will have seen that that act, the 1983 Act, consolidated preceding legislation, including the 1949 Act, which in turn had consolidated earlier legislation. So one can trace through to the Victorian legislation, which was designed to overcome the difficulties which had been encountered and the desire, especially after the secret ballot was introduced in 1872, to secure a fair and level playing field as far as the election was concerned. Now, the court has, in Authorities Volume 1, at page 491 and following, section 72 to 90, section 72 onwards to section 90 of the Act as enacted. And the control which was in place by way of limit on expenditure to achieve that level playing field was achieved in a number of ways. The first way was that those who provided services or facilities were subject to a strict time bar. In other words, a candidate couldn't put off paying for an expense presently incurred by having it paid for some time later. And the provider, therefore, if he was going to be paid, was subject to the strict time bar which is set out in section 78. Time for sending in and paying claims. That was an element of control. A second element of control was that contracts had to be made in a particular way. That is section 72 at page 491. And payments had to be made in a particular way. That is section 73. And might I ask the court, please, to note a counterpoint which arises here. Section 72 talks of, subsection 2, contracts by which election expenses are incurred, and section 73 talks of payment. And in other places in the legislation, that contrast obtains, distinguishing between the circumstance of payment having been made and an expense having been incurred, for which payment, of course, may come later. It is not, contrary to a submission which the respondents make, any indication that incurred is synonymous with authorised, for authorised is used in the legislation to describe certain people as having been authorised to do things.
We get authorised in the 1983 Act.
Yes. And this Act that you are looking at now, my Lord, is the 1983 Act as enacted.
Yeah, I mean, as enacted.
And the legislation which I've shown you so far, section 72 has come to be, in consequence of certain alterations, removed, and the other legislation is altered, but the thrust of the legislation remains exactly as it was in Victorian times. The third element of control was that promotional or procurement expenses of a certain type could not be incurred other than by the election agent and that is section 75, so that an outsider, so to speak, was not able to incur expenses, section 75, page 493, to come along and to hold a public meeting and incur an expense thereby. There was a financial permission in the sense, as your lordships will, as the court will see, at 75(1)(2), about halfway down the page, non-application to expenses not exceeding in the aggregate the sum of 50 pence. 50 pence was the translation in the 1983 Act of 10 shillings in the 1949 Act. And 50 pence became £5 2 years later by a Representation of the People Act 1985. And then in consequence of a case called Bowman, came to be changed because the Bowman case said that that could be seen as an inhibition on free speech. But one can see how remarkably restrained the position was in terms of thou shalt not incur expense. And fourth, the expenses were limited to a specified amount which is given by section 76, page 494, and it's done by reference to numbers in the sense that page 495 at the top, you get slightly more if you're in a county constituency than if you're in a borough constituency, because no doubt one has to move about more within the county constituency. I should have mentioned, when I referred to the case in passing called Bowman, that case is in the Authorities Volume 1 at page 692. Now, my Lord, the position I've just described is one which had been the position since at least the Corrupt and Illegal Practices Prevention Act of 1883. You have that, the court has that in the same volume, and if I just spend a moment on that, it's section 7, page 652, which provides the then limit, similar to the position that we've seen for outsiders in the present legislation. And it's interesting to observe by section 1 on page 650 that previous to the 1883 Act, persons other than candidates at parliamentary elections had not been liable for treating. In other words, the sorts of activities vividly described by Charles Dickens in the Pickwick Papers had not been prohibited of those, but had been prohibited of the candidates. But now, with the 1883 Act, the modern system is in place. Now, the Representation of the People Act, the court may have appreciated, 1983, was remarkably restrained about political parties. In fact, it didn't mention them at all. And parties didn't enter into any question of electoral law until 1998, with the Registration of Political Parties Act, and that was for the purpose of registration and to overcome a problem which had been identified in litigation which had happened 4 or 5 years before concerning a gentleman who stood as a literal Democrat to the chagrin of the Liberal Democrats and managed to achieve from a standing start a very considerable number of votes. And so that was done for that purpose, to enable names of parties to appear on ballot papers and to exclude the misleading use of such names. It wasn't until the Political Parties Act of 2000 which set up a system for the control of campaign expenditure by parties. What that 2000 Act did was to introduce sections 90A, 90B, and 90C into the Representation of the People Act. And in the additional bundle of authorities that was provided to the court yesterday, I believe, behind flag 2, the court will find at a page numbered 36 what is Part 8 of the Political Parties Elections and Referendums Act 2000. And if I could just draw to the court's attention, please, on page 36, section 131.
I'm sorry, are we looking at this?
It's the new volume. Yes, my lady.
We are.
Yes.
Yes.
And
Have we got it electronically?
I think the answer is yes, but I haven't got the electronic references.
So we're looking at
Page 36, behind flag 2, and it's section 131 of the Political Parties Elections and Referendums Act, which provides the amendment to section 75, section 75 being heavily relied upon by the respondents. And the amendment which is put forward under the heading election expenses incurred otherwise than by candidate. And can we just note there, my lady, my lords, that it appears to be suggested by the respondents that election expenses cannot be incurred other than by a candidate. But plainly they can. And here we see section 75 indicating amendments to introduce subsection 3, a permitted sum of £500. That is to do with, and in consequence of, the Bowman case, where the European Court of Human Rights said 10 shillings or £5 was not sufficient.
That's the figure that's now 700.
Now 700, my lord, yes. And the position was this, that section 76 also came to be amended, as one sees from section 132, to describe the election expenses incurred by or on behalf of a candidate at an election must not in the aggregate exceed a given figure. And that was of significance because up until this time, election expenses as a phrase had not been defined in the legislation. But the phrase election expenses was there used in that way. And so it became necessary, and this was done, as one sees on page 39, through section 134, introducing section 90A, to define election expenses. And so election expenses come to be defined in the way they're set out. And section 90B, if I can just touch upon this to deal with an incidental point which is made by the respondents, deals with the incurring of election expenses for the purposes of section 90A, and is designed to cover the circumstance where a proportion is to be assigned to an election. The particular purpose behind section 90B was to deal with the situation which is frequently the case, namely that an election occurs alongside another election.
So contemporaneous elections.
Yes, exactly. You have within the rules always providing for combination rules so that, as the court will know, it will frequently be the case at a parliamentary election that there will be at the same time in given places, not necessarily invariably, a by-election for the county council, a by-election for the borough council, or whatever it may be. Alternatively, one might have coincided the parliamentary election with the way in which local elections are organised, because local elections always occur on the first Thursday in May under the local government legislation. So there was a concern about that particular aspect. 90C then deals, and it becomes our section with which we're particularly concerned, with a different matter: property, goods, services provided free of charge or at a discount. Now, what then happened was that sections 90A and 90B came to be replaced by 90ZA in consequence of the Electoral Administration Act of 2006, and that introduced a schedule, and it also introduced the ability for the Electoral Commission to give guidance. And so 90B came to be unnecessary, and 90ZA carried the definition of election expenses. Now, the court has the position as far as 90ZA and 90C as they are now in Authorities Volume 1, Memory Stick Reference 445 for 90ZA and 90C 446. And we respectfully observe that the most cumbersome matter about 90C at 446 is that it is dealing with a variety of circumstances. There are multiple possibilities that the section has to embrace. So it has to embrace, on the one hand, free provision. It also has to embrace, on the other hand, discounted provision. It also has to cover property, goods, services, and facilities. So that there are multiple potential components within 90C, which makes it a difficult section to read, so to speak, straight through and gain a clear understanding of it. However, how it actually operates, of course, is that there will be identifiable matters which can be then traced through 90C to see how it operates. So that if the court keep open 90C and have the core volume at page 272, that is to say, memory stick page 272. The court will find itself within a document prepared by the prosecution describing the character of the evidence that was desired to be called, and one can observe on the facing page 271, services, salaries, and then illustrations are given, 272. Most straightforward example of these three is Taylor, a prosecution witness. He was dispatched by his employer, and then it describes what he did. I skip through it all because the court will have had an opportunity to see, and a further opportunity hereafter to see, that which he did, but he was being paid not by the candidate, but by a party organisation or an organisation associated with the party. And the same holds true of a further participant at the election, Little, who in fact is a defendant as well. And the document is divided into services, salaries, accommodation, page 276, transport, page 282, room hire, 283, advertising rosettes, 284, public meetings, 285, so as to embrace those matters which can all be found within the rubric of election expenses. But if one takes any one of those particular matters, one can follow through how section 90C operates, so that if the court, having in mind services, goes back to 446, 90C1, this section applies where in the case of a candidate at an election, I skip on to Roman 2, services are provided for the use or benefit of the candidate free of charge, and the services are made use of by or on behalf of the candidate in circumstances such that if any expenses were to be, in other words, it's contemplating a hypothesis, were to be actually incurred by or on behalf of the candidate in respect of that use, they would be election expenses incurred by or on behalf of the candidate. And one can do a similar operation for whichever category one finds, but it enables the language of section 90C to be seen to operate. But it is of the utmost importance, we respectfully submit, to have in mind that these things at least are happening in section 90C1. Something, here I'm talking about services, are provided for the use or benefit of the candidate, free. They're made use of by or on behalf of the candidate in circumstances that if, and here one gets into the contemplating the situation which is not the true situation, because we know that the cost of these items has been met by someone else, that if any expenses were to be incurred by or on behalf of the candidate in respect of that use, they would be election expenses incurred by or on behalf of the candidate. And so the purpose for that is to ensure that we only bring within 90C that which is provided for the candidate, that which is made use of by the candidate, and that the use is in circumstances when, if it had been an actual expense incurred by or on behalf of the candidate, it would have been an election expense. So obviously it eliminates what might be described as a gift apart from the election, but it embraces those matters used by the candidate for the election, which would, had he or she paid out the money as the candidate, incurred that particular expense.
What is meant by use being made of property, goods, services or facilities by or on behalf of the candidate? The written cases contain examples of services or which are designed to promote a candidate, but about which the candidate is unaware, or to which the candidate doesn't consent. Is it sufficient that there are campaigning services for the benefit of the candidate if the candidate isn't involved and disclaims them or would disclaim them?
The position goes as follows, my lord. First, there has to be provision for the use or benefit of the candidate. So there's that provision aspect. And second, there has to be made use of by or on behalf of the candidate. And your lordship asks me, what does that signify? Does it signify, and here, if I may, I take it slightly further, an adventitious benefit to the candidate arising from the visit to the constituency of a well-known personality, or the adventitious benefit to the candidate of some announcement which serves to reveal that his party is in good stead rather than in ill stead. Now, the position there is that a purely adventitious circumstance is not one which is provided for the use or benefit of the candidate or made use of by or on behalf of the candidate. So that, as I say, if a famous personality arrives voluntarily, spontaneously, without reference to the candidate, and seeks, say, to disparage the other candidates, then the candidate may be advantaged in the sense of some voters feeling those other candidates have all been well disparaged by the famous personality who turned up, and therefore I'm only left with that other candidate. But the candidate has not been provided those services or made use of those services in circumstances such that if expenses were to be actually incurred by or on behalf of the candidate, etc., reading through the balance of 90C 1B. May I take another example to answer this particular point? One circumstance which is undoubtedly an election expense and is itemised in the schedule, Schedule 4A, would be the hiring of a hall in order to make a speech.
By who? A speech by?
Well, I stopped there because one can contemplate at least two circumstances. One can contemplate the circumstance where, and Mrs. Bowman is actually quite a good example of this. She was a lady who was concerned about the abortion laws and seeking to promote a particular point of view and inquire about the candidates generally, their position. And so she comes, or someone such as her comes with a concern about the abortion laws, hires a hall, and makes a speech about it. Makes a speech about it with a view to stimulating thought by the electorate, for an election is going on, about that very matter, so that, which is what Mrs. Bowman wanted, they were forced to ask questions of the candidates. She does it all without reference to the candidate, and the candidate is not invited to, nor does he arrive at the hall to make any speech at all. However, it stands to his advantage because it so happens that his position is on the speaker's favoured side as opposed to her unfavoured side. It just happens to be like that. On the other hand, one has a circumstance where the hall is hired and provided for the candidate. And so the candidate attends at the hall and makes use of the facilities in the hall, makes use of the opportunity presented so as to address the crowd that have assembled. Makes a speech, answers questions, does whatever he wants to do.
So he uses it, you say?
Yes, absolutely.
Yeah.
And so you can have a clear divide in those sorts of circumstances, and you have a clear divide in other circumstances as well, because you are always looking for provision for the use or benefit of the candidate and making use of by or on behalf of the candidate.
What if somebody hires a hall and makes a speech saying support the candidate's party without ever mentioning the candidate?
And that is done without reference to the candidate and without the hall being provided for or any use being made by or on behalf of the candidate.
So the candidate has to be named?
No, the candidate has to be the person provided, the item has to be provided for the use of the benefit of the candidate, and he has to make use of the matter. If I, as an interested observer, turn up in a constituency in Scotland because I'm concerned about whether Scotland goes independent or not and wish to make a speech and that supports someone, I'm just doing that as a volunteer.
No, I wasn't thinking of that. I was thinking of something much more likely to happen, which is a prominent member of a political party comes to the constituency, a hall is hired, and that prominent member of the political party doesn't mention the candidate, but says, vote for that particular party. That clearly is benefiting the candidate, intended to benefit the candidate, but is it made use of by the candidate?
I would say, in the circumstance that my lady describes, no. The situation is one whereby it is perfectly possible to see that the party's campaign will advantage a candidate because of the association between the candidate and the party. But if one travels back to the circumstance of the prominent figure in political party turns up, makes a speech in a constituency, and by definition it's going to be a constituency if we're talking about a general election, makes a speech in a constituency in which he or she extols the virtues of the political party and exhorts those listening, whether there or on the television, exhorts them to vote for party A or B, as the case may be, that is something which is being done as part and parcel of the party campaign. It is not the provision in the circumstance just described of property, goods, services or facilities for the use or benefit of the candidate free of charge.
Well, it's obviously for the benefit of the candidate.
Yes.
Wouldn't be doing it otherwise.
It's not use, your point is, it's
Well,
not
it's
use.
use or benefit.
Yes.
Well, I know, but in the next
It's
B.
the next thing. No, I'm
Yes,
going
B.
on to the next
Yeah.
thing.
Yes.
What is clear is subsection 1A2 has the word use or benefit, and B does not refer to benefit.
Made
Yes,
use
use of is simply made use of.
Yes.
That's the point
by
I was
or-
getting
yes.
at.
Precisely.
That sort of activity clearly benefits the candidate, so falls within little 2, but is it made use of by the candidate other than by his passive acceptance of that benefit?
Well, remember, my lady, it has to be provided for the use or benefit of the candidate free of charge.
Oh, I see. So it wouldn't be sufficient if, on hearing of the arrival of the important personality, the candidate enthusiastically rushed round and said, thank you very much for coming to support me. Because if you put the word emphasis on the word provided, that suggests that it's something in the state of the mind of the important personality or the political party. And if he wasn't expecting this, then it wasn't provided. I mean, there's some fine distinctions, but is that where we get to?
I'm simply seeking to utilise all those words within 1A2, provided for the use
I mean, it's
or benefit of the candidate.
It is obviously provided for the use or benefit of the candidate, I think.
is, yeah.
Well,
So the question is whether the candidate rushes round and shakes the hand of the important personality, is it?
Well, yes, but then one's also got to remember that it's actually got to be made use of by or on behalf of the candidate in particular
That was the point I
circumstances.
was making,
Yes.
that it seems likely that the example I have given would fall within little 2, but the question is whether it falls within B.
Yes, because...
Is this what you mean by adventitious?
Well, yes, because there are plainly going to be a range of adventitious circumstances which will benefit...
Yes, but the
or
interesting
disbenefit.
ones are the ones that are closest to the bone, aren't
Yes, yes, exactly. But here we have not the kind of examples that have just been exchanged, but a clear circumstance of those services by way of staff being provided, the accommodation being provided, the transport being provided for workers for a particular candidate, the view being this candidate must be supported so as to secure that the opposing candidate, the UKIP leader, was not elected. And there was therefore a circumstance, we respectfully say, which is clear, that there was provision for the use or benefit of the candidate free of charge and made use of by or on behalf of the candidate.
I absolutely understand about the clear divide, which was your expression, between the two examples you gave by reference to Mrs. Bowman. The candidate who doesn't turn up simply lets her get on with making her speech, you would say isn't making use of her contribution to the public debate. What happens if he does go? Sits at the back of the hall.
Well, if he simply goes and sits in the back of the hall and listens to what she says and thereafter guides himself, so to speak, accordingly.
Well, what does that mean? I mean, it's not the question in this case, and I don't want to spend a lot of time on it, but what I was simply getting at was whether there was always the kind of clear divide of which you spoke.
Well, my lord, the position will be one where there are going to be instances where it is going to be more difficult to say, or for someone like me to say, there is that clear divide. I must accept that.
Sits at the back of the hall, listens, afterwards stands in the foyer, and as the attenders at the event leave, when asked by them where he stands on this particular issue, gives them his answer. Is that using the services of Mrs. Berman or not?
Well, I would respectfully say that it's not in that circumstance. He's just, the candidate has just happened to be there and has responded. He hasn't had provided for him those particular matters set out in 1A2, and he hasn't made use of, by or on behalf of the candidate, the services or facilities in B in circumstances such that it would have been an election expense had he actually incurred the expense. What this section is driving at is a situation where somebody pays for something, that something is provided to or transferred to, when one's talking about property or goods, transferred to or provided for, made use of by, and so you've got a clear chain of financier, transfer or provision, made use of by or on behalf of the candidate in circumstances that it would have been if the candidate had been paying for it, an election expense, so that you avoid the situation of the candidate being able to ride on the back, so to speak, of financiers or others who are doing what I've just described.
Well, we understand what it's getting at
Yes.
and what you're getting at, but we're trying to test the boundaries of what it applies to.
Yes, and those lead to, of course, and perhaps I anticipate to a certain extent, if I may, what we set out in paragraph 27 of our case. Namely that, and this is MS page 78, that the application of section 90C is fact-specific, and that's reflected by the character of the discussion that we've been having. So that the first question is, as they're set out, whether free or discounted property, goods, services or facilities were provided for the use or benefit of the candidate. That's the first question. And then if yes, the second question is terms of section 90C1B, whether the goods, services or facilities were made use of by or on behalf of the candidate. And if yes, the third question is also given by 90C1B, were they used in circumstances where, if actually incurred by or on behalf of the candidate, they would have been election expenses incurred by or on his behalf. Now, I respectfully observe, if I may, that there's an important point consequential upon the identification of these questions, namely that Parliament plainly intended that section 90C was capable of being used to inform a criminal charge, because It takes the step of indicating what is a corrupt practice, takes the step of providing for a prosecution for the corrupt practice, takes the step of saying that that corrupt practice can be tried on indictment. So that it must be taken, I respectfully suggest, to be the case that Parliament proceeded upon, and we should proceed upon the footing, that there are questions capable of being identified for a jury from the terms of Section 90C. And Section 90C does enable those questions to be provided. There may be circumstances where it is going to be abundantly plain. The financier has done what I've just described, and there may be circumstances when it is less plain. But nonetheless, the important matter is, can the questions be identified for the settlement of the matter by the jury? And I respectfully say, alongside that, as set out in the case, that it is important not to introduce words or other questions than those actually provided for by Section 90C, because the court will have in mind, in particular, the character of the submissions by the respondents and the judgment of the Court of Appeal saying that one had to, so to speak, search around for authorization in connection with this matter, rather than those particular steps there set out at paragraph 27.
I think one of the problems about authorization is that under the statute 90ZA subsection 4, it's directly related to the incurring of election expenses, and by definition we're talking about something here which hasn't been incurred and wasn't authorized. I mean, and I agree paraphrases are always dangerous, but I have a feeling that you're, if one were to paraphrase, accepting something as akin to this as a paraphrase for May's use of, something like endorsed.
Yes, I would wish to go slightly further than just endorsed, because made use of, I respectfully suggest, indicates some degree of positive activity, if I can say that, rather than which endorsement might signify, I simply endorse what X or Y says.
Yes, I can see that. I mean, if on hearing that the important person was coming, the candidate simply sent a message to head office saying, I'm delighted to hear that he's coming, in a sense that would be endorsement, but it wouldn't be sufficient.
Yes, yes, and it may very well be the case, my lord, that the important person from head office arrives and the important person from head office rings up in advance and says, I am arriving, and then the candidate is there to shake him by the hand and endorse the important person from head office.
I mean, which side of the line does that fall?
Well, I would suggest that appears more on the I endorse the leader of the party rather than I stand in opposition to the leader of the party rather than the making use of. But it's not this case, my lord, and
yes.
It's not a...
You would say this case is...
it's not a question which, with the greatest respect, one needs to be able to provide a definitive answer to, because the definitive answer that we seek is the answer that what you don't need on the question as posed by the Court of Appeal is authorization, and what you do need to do is to meet the terms of Section 90C, with those terms being capable of being determined by a jury, because it's plain that this is something which is intended to, at some stage, end up in front of a jury. Now, can I just travel back for a moment to an observation which I made earlier about 90C, namely that it deals first with the question of transfer or provision, and then it demands that the use be done in particular circumstances. If they were actually incurred, they would be election expenses. So that obviously one reads across to section 90ZA, and incurred by or on behalf of the candidate. And so the position there is once again that 90ZA is the provision which tells us when circumstances are incurred by or on behalf of the candidate. And so it's making plain, I say, that these are matters not independent of the candidate, but part and parcel of his campaign. Now, in the...
Does that mean, just to understand your point, that in 90C1B, where it talks of by or on behalf of the candidate, we should also be looking for someone authorised by the candidate or the election agent using the material.
Does your Lordship have the words 90C1 at the end of B in mind?
It was going back to your earlier point. The property, goods, services, or facilities is or are made use of by or on behalf of the candidate. It was what was meant by on behalf of the candidate in that context. I mean, can we read across to 90ZA to get help there or not?
I would say not for that.
No.
You can't get help from 90ZA there.
No,
90ZA is simply giving meaning to certain expressions.
Yes.
And 90ZA4 gives meaning to the expression incurred by or on behalf of a candidate, by the candidate or his election agent. Now, you need that meaning because if your Lordship looks back to section 81, 1A at 436, you've got the expression incurred by or on behalf of the candidate. You've got the same expression in section 76(1), and you've got the same expression in another section, section 73. And so the draftsman of this legislation plainly took the view that it made sense to indicate what was meant by incurred by or on behalf of a candidate.
Yes. I see it's been it's defining that expression in the context of expenses, but I was wondering, in the three questions that you have to ask the jury, when the jury are told in your question B on paragraph 27 of your case that the services are made use of by or on behalf of the candidate, what is on behalf of the candidate?
On behalf of the candidate would embrace this circumstance.
But subsection 4 is not a definition of on behalf of the candidate, is it? It's a definition of incurred by or on behalf
Yes,
of the candidate.
yes, exactly.
It's not the expression used in section 90C.
That's absolutely right, my lady.
Accept that.
And I was drawing attention to the fact that 97A4 is simply indicating when that circumstance arise of incurred by or on behalf of a candidate. It's not to do with, and as a mistake I would respectfully say made by the Court of Appeal and the respondents in assigning to the language on behalf of the candidate a cross-reference to incurred by or on behalf of the candidate.
I understand that position,
Yes.
but if you are correct about that, can you explain to me what the jury is to understand by the expression used on behalf of the candidate?
Yes, the use on behalf of the candidate would arise in this sort of circumstance. At an election, a candidate will have an agent who is appointed and identified, and also will have agents, for that expression as a matter of electoral law carries a wider definition than it does for purposes of the law of agency, for example. And an agent of the candidate may be someone who's sent out canvassing on the agent's behalf, or to speak on the agent's behalf, or something of that sort, so that one provides something for the use or benefit of the candidate. It's then made use of on behalf of the candidate by the agents of the candidate going around with it and delivering it if it's handbills or something of that sort.
That means any of the campaign workers, does it?
Yes, because, as I say, agent for a candidate is given a wide meaning so as to secure that you don't enable a candidate to escape, whether it's for this or any other particular matter, liability by hiding behind. Joe Bloggs did that, and Joe Bloggs, he might have come to my committee rooms every day and I might have greeted him like a long-lost friend every day, but he wasn't someone on my behalf, he wasn't an agent. And so the law as far as elections is concerned is clear, that one has a broad definition of who is an agent.
Doesn't it raise a question of the authority of the worker or the volunteer?
It may well do, my lord, because the position at an election, of course, is always going to be one whereby you will have a lot of people seeking to intervene in their own way, and there will be some who will be doing it in the way that I've just described, who will be people who one can properly say, this person has been authorized by the candidate to go out tramping the streets and to shake hands and to say, please vote for me or don't vote for him. On the other hand, there will be people who just come in as interlopers, if you like, and who will participate, but won't have any of that authority behind them, which the circumstance I've described will have otherwise given to them. So it's not a matter of a formal document of agency being required. It's a matter of the candidate having identified who are her party workers, agents for the purpose of this campaign, so that you will then have and may then have your question of authority.
So if an individual worker falls into that category, are you saying they'd have an ostensible authority or actual authority to embrace the services provided by the celebrity?
Well, the position there is that the services are being made use of on behalf of the candidate, because we are supposing someone who is part of the campaign team, someone who can properly be described as an agent of the candidate, and he is 90C1B, by or on behalf of the candidate, using whatever it is we are talking about as having been provided free of charge. That's how that goes, my lord. And it has to go that way because first, that's what the section actually says, and second, which is an important feature to have in mind, is that considerable responsibility rests upon the candidate as far as his campaign is concerned, so that he or she must take some degree of responsibility for that campaign. And we mustn't also forget that if things can go wrong, do go wrong, there are ways and means of a candidate being excused from liability, because applications to the court can be made to say, no, I didn't know anything about that. I don't want to have anything to do with that.
To be on the candidate's behalf, though, it would actually have to be with either actual or implied, or express or implied authority. If some staffer engrossed or in breach of the candidate's instructions and secretly took advantage of some services which were being provided for the use or benefit of the candidate, I question whether, would you say that that was caught?
No, I would agree with your lordship there. Ultimately, this gets back to the fact that we've got questions for the jury to ask and answer, and we've also got to touch this with, well, as the jury would touch it with, the common sense of determining. My Lord Mance conjectures someone who goes off on, if I may change the terminology, a kind of frolic of his own, and then the exchange between me and my Lord Lloyd-Jones was to the effect that you can have quite a wide range of people who may be on behalf of the candidate, but ultimately you've got there a question of fact to be determined here, and to be determined here in accordance with the questions which can be derived from section 90C, always bearing in mind you've got to be able to identify questions from section 90C.
Did I understand you to say that there was some established election law about when individual workers count as agents? I don't mean, of course, the agent. I mean
yes.
the candidate.
There is. We
agent.
haven't got that in front of the
There is some,
court.
is there?
There is some, certainly.
Does it goes into the kind of authority they need to have, does it?
It certainly describes those who fall within the rubric of this particular matter. And no doubt we can give further and better particulars of that particular matter to the court.
It's just that it exists.
Yes, it undoubtedly exists, and it undoubtedly is of a category of people who, if one was talking about strict contractual liability or matters of those terms, one wouldn't necessarily ascribe to them the word agent.
Well, I wouldn't wish to detain you with limited time, but I welcome a short note on what those provisions are.
Certainly.
Yeah. Thank you.
Can I then go back to section 90C 1B, and in particular the words in section 90C 1B which actually occurred by or on behalf of the candidate in respect of that use. They would be or are election expenses incurred by or on behalf of the candidate. And the Court of Appeal indicated that we were not making sufficient reference to those, or were regarding those words as somehow not playing a part. The reason why those words are there is because one has in the return which has to be made a return of expenses incurred by or on behalf of the candidate, 81(1)(a), and because also you want to distinguish between the circumstance when they would be incurred by or on behalf of the candidate, or an election expense incurred by another. And it is undoubtedly the case that election expenses can be incurred by others. Section 75 has been heavily relied upon by the respondents, page 423. I'm going to be very quick about Section 75, if I may. Section 75 deals with certain expenses by itemising them 1A, B, C and D, indicates at 1ZZB, top of 424, that it doesn't apply to expenses incurred by any person which don't exceed in the aggregate the permitted sum, that's now £700. And then if one goes over that sum, subsection 2, there has to be a return in relation to that particular matter, which has to be in a prescribed form, which you have in the additional bundle of authorities through subsection 3. But the short point is that Section 75 enables someone to incur an election expense which is nothing to do with the candidate, on the other hand, Section 75 enables money to be spent up to £700 with a provision whereby the Electoral Commission can ask details if you spend more than £200, so that it is perfectly possible for someone using Section 75 to provide finance within Section 90C.
I'm becoming a little lost, I think. Yeah.
You've got a lot of puzzled faces on the bench, Mr. Straker. We don't understand what you're saying.
I probably took that too fast, because, and the reason being that there was a lot of discussion about Section 75 below, and a lot of discussion in the cases about Section 75, which is probably by the by, and so one doesn't actually want to get too bogged down in Section 75.
Well, does Section 75 cover the important person coming without the candidate's involvement? On the face of it, why not?
No.
Why not? He comes to promote a candidate.
I see what you mean, my lord, sorry.
Yes. Comes to promote a candidate. He doesn't inform the candidate. The candidate is not in any way involved, but he holds a public meeting. So would he be limited?
Yes. The position is that the important person just described is capable of falling within Section 75 because of the holding of the public meeting or organising a public display, quite clearly so.
Yeah.
The important person, to take the matter slightly further forward in Section 75, if he is operating, so to speak, entirely separately from the candidate, is able to spend up to £700. If he spends more, the position is required to be authorised. See subsections 2 and 3 on page 424 of Section 75. The point where I suspect I caused the confusion, my fault, I'm sure, is that I contemplated the circumstance of someone appearing and spending, say, £500 on goods or services or a facility, saying to the candidate, would you like this? I'm providing this to you. The candidate saying, yes, please, I want to make use of that because, making use of that, and then the situation would be that would fall within, as it appears, Section 90C.
It doesn't.
would appear to fall within section 90C.
That was not what we understood you to say when you...
Oh, I'm sorry. Well, it's entirely my fault.
Well, you said it was capable of falling.
Yes.
But you said it was perfectly possible for someone to provide finance within Section 90C.
Yes.
Those are your words. But they came after a blurb which suggested that that would not be...
Oh, well, I'm sorry about that, because I was drawing
Impermissible,
attention, or
say.
trying to draw attention in an abbreviated way to the fact that Section 75 can cover a range of different circumstances, and one of those circumstances could be within Section 90C. That's the point. And the situation is one whereby it's something of a diversion, I would respectfully say, on the part of the respondents when they rely upon Section 75 and say, well, there's a permitted sum of £700, and that enables all sorts of things to run free of control within the election, and that is not so.
As long as the candidate or someone on his behalf makes use
Yes.
of the service provided.
Yeah, absolutely, my lord, absolutely. And that's why it should be. And bear in mind, too, that if one's seeking to say that one can have £700 times a few, it wouldn't take long before one reached the limit of the campaign.
Well, you can't have lots of 700s if they're concerted.
No, if they're
in the event,
concerted,
can
but if
you?
you had 10 unconcerted, you soon get to a very substantial proportion of the overall sum, which is why it must be the case, I respectfully say, that at least capability of falling within Section 90C. But I'm sorry, my lady, if taking it in that way added to an element of confusion rather than clarity.
I think we now understand what you were
good.
trying to say, yes.
Well, 75 creates an offence, doesn't it? 75,
Yes.
It's in 75.5. The offender is not the candidate or any of his workers.
That's the important person.
It's the third party
Yes.
who's spending the £699. Oh, sorry,
Spending
£701. Yes, yes, I
That's
see.
right.
Right,
And he's guilty of a corrupt practice.
yeah.
Well, the offence is not committed by the person who incurs the expense, but... yes, it is.
It is.
Yes, if a person incurs,
Thank you.
etc., any expense in contravention of the section, and the section precludes you from incurring more than £700.
You say 90C operates simply in parallel with that.
Yeah.
It may still catch even the £699
If the £699,
made use of.
exactly, here it is to the candidate, and I rhetorically ask, why not in that circumstance? It's fair and square within Section 90C, and these sections should, and do, I say, operate independently. And the court may have observed that we've referred to the item of construction as indicated in Hallsbury statutes by the late Mr. Benyon, that the section, one section, is intended to have and to convey a single message. And the single message of Section 90C is that if X, then Y.
Tell me, how does Section 75 fit in with party financing and at the national level? Is this a...
The answer to your Lordship's question is that there is no immediate fit between Section 75 and party funding. The reason why there is no immediate fit between Section 75 and party funding is as follows, that Section 75, as it is, or as it largely is, was enacted in 1983 prior to any involvement of political parties and any control of their funding. And one of the points which I desire to make, that third point which I observed, is that we have to be careful to remember, I respectfully say, that the question of election expenses for candidates is one which operates before anything arises with regards to party financing, which is all reported later, which operates independently of party financing, so that, if I can do this in an abbreviated way, the position is one whereby you have a very strict time limit for petitions, but the timescale for a return for your expenses is 35 days, which is more than the 21 days for the petition, but the limit on petitions is extended so that if something emerges from the return which is defective, then the period for the petition is extended. And in the additional bundle of authorities, you've got the provision, section 122, I think it is, of the Representation of the People Act, which makes that extension both for local and for parliamentary elections. So it all precedes this. So to answer my Lord's question, the reason why the position is one whereby I say there's no immediate fit is because of that circumstance.
Chronological.
Yeah.
But I mean, it must create some difficulties. How do you know whether you're promoting or procuring the election of a candidate rather than of all candidates in your party?
Yes,
I mean,
and we have the benefit here today of the Electoral Commission, and the candidates and the parties always have the benefit of advice from the Electoral Commission as to how best to proceed in the various circumstances which can arise. And you may have seen, my Lord, that certain of the guidance produced by the Commission has been made available to the Supreme Court.
Yeah.
Now, can I say just a little about section 90ZA? First, this is page 445 of the authorities volume, subsection 1 was necessary because there was a change to section 76 which warranted a need for a definition. Subsection 2 was needed because of the introduction of Schedule 4A, which hadn't previously been present. Section 3 defines a phrase which is used in 90ZA and 90, but not 90C, although it's referred to by the respondents. Subsection 4 is the one relied upon by the respondents and the Court of Appeal to introduce into section 90C a requirement of authorization of the expense incurred, but the position is one whereby election expenses as referred to in 4, of course, means that which is set out in subsection 1, and so it means subject to section 90C below. And furthermore, the position is one whereby you use section 90ZA4 in the hypothesis that you are concerned with under 90C B, 1B. You don't use it for a pretense that the expense has been incurred, or you don't use it to say that the expense must be incurred by the candidate or his agent, which is what the Court of Appeal and the respondents are saying. Consequently, I respectfully say that we can be sure that section 90C is, as its language says, a true deeming provision, which means that one has to give a particular answer to the certified question, and a positive answer to the certified question is clearly wrong when it says you need authority. Now that is the heart of the matter and invites the court to consider 90C and 90ZA4. I've also submitted and do submit that 90ZA4 has been misunderstood. And can I do that by reference to the judgment at page 129, memory stick page, at paragraph 29. And here, the Court of Appeal say that section 90ZA has to be viewed in the context of the overall regime. I respectfully say that the context we have to remember is this. The Political Parties Act of 2000 is not an act which falls within those acts to be cited as the Representation of the People Acts. You've got section 207, which says that the RPA 1983 is. I can give you a list, if needs be, of the other acts which are cited as Representation of the People Acts, but it does not include the 2000 Act.
Section
207 of the Representation of the People Act 1983 says this act is. There are other sections, and I could recite, if your Lordship wanted me, a list of those which presently do, but it's a negative point because the Political Parties Elections and Referendums Act is not within the categorisation. And it's not surprising that such is the case because independents are necessarily not within the Political Parties Act of 2000. And everything in respect of candidates precedes the question dealing with parties. And I gave the references for the extension of time for petitions. That's 1223 and 1224 of the Representation of the People Act. Paragraph 30 we have looked at, but if the court would be so kind as to go again to paragraph 30, there's a sentence which begins in the middle of the paragraph, if these were incurred by the agent, referring to certain expenses, the candidate or someone authorised on their behalf, they would fall within the definition of election expenses incurred by or on behalf of the candidate in section 90ZA4. But that seems to suggest that 90ZA4 plays a part in defining election expenses, which it doesn't. And it doesn't pay attention to, I respectfully say, the deeming aspect of section 90C. Paragraph 31 of the judgment, foot of page 129, top of page 130, is, I suggest, a paragraph which is difficult to read side by side with section 90C. It appears to suggest that the provision of gratuitous goods, services, or relevant discount must nevertheless be authorised by the candidate or the election agent or someone on their behalf, in the sense that they've agreed to receive them. The respondents say authorised equals incurred. The Court of Appeal don't seem to go as far as that, but do seek something other than that which is set out in section 90C. Paragraph 34 refers to 90ZA4 applying for the purposes of this part of this Act, which includes 90C. And then it says, it follows that its provisions bite on section 90C. But the point is that 90ZA4 is simply giving meaning to an expression, as we've discussed earlier, incurred by or on behalf of a candidate, by extending it to the person authorized by the candidate or the candidate's agent. It only bites on 90C in the sense of giving an extension of meaning in 90C1B of incurred by or on behalf of the candidate. And it doesn't, importantly, turn 1B from a hypothesis into reality. At paragraph 42, effect of construction advanced by the prosecution is to attribute an intention that section 90C should be a freestanding provision which removed the requirement that election expenses which fall to be accounted for in the return, which for these purposes were notional, must be incurred at least with the authority of the candidate or his election agent. And then they refer to a case which harks back to an old Irish case dealing with the question as who is the person to be the paymaster for the candidate. But the point is that what the Court of Appeal have done is to write into section 90C authorization, authority, when that doesn't appear in section 90C, and to indicate that you cannot have, effectively, a circumstance where you get a financier who can provide matters for a candidate without that having to be accounted for. And then paragraph 43 touches upon this question of use on behalf of and examples removed from the facts of the case. And here we get into the circumstance of the conjecturing of various circumstances which might or might not arise. We have a complete answer, I would respectfully say, to the difficulties which are canvassed within this paragraph and the suggestion that you can have ignorance of a matter by the candidate. First of all, it has to be transferred to, provision to, provided to, use of, on behalf of. Secondly, the election campaign is one in which the agents will necessarily be incurring, quite apart from 90C, expenses of which the candidate may be unaware because they've been authorized so to do. And third, this paragraph 43 gives no meaning at all to the deeming approach of section 90C. Now, my lady, that effectively brings a conclusion to the first two submissions which I made, namely the overarching submission 90C and 90ZA4, what do they mean, together with this misunderstanding of 90ZA4. Necessarily, I've taken it at something of a pace. The position as far as the third submission is simply this question of the Political Parties Act and how that stands vis-à-vis the Representation of the People Act. I've made the observation about what can be cited as. That by itself, I would readily recognize, cannot be taken to say, oh, well, we can't address our mind at all to the 2000 Act or the consequences of it. But it needs to be remembered, I respectfully submit, why we have the party legislation, how that came to pass, And we need to remember that it came to pass not merely because of the Liberal Democrat controversy, but also because it was found sensible, separately and additionally, to deal with the question of party funding and party activity, so that you have registered parties who are registered to the exclusion of minor parties. The registered parties will participate in an election at a number of constituencies and to seek party advantage. And that is what is governed by the party campaign. And nothing within that affects or undermines the position as far as the candidates are concerned and the local position in terms of the expenses which they can pay. And we also should bear in mind throughout that particular exercise that Parliament has done nothing to stand in the way of the independent candidate, or to make life more difficult, or to advance away from the Victorian concept that you're trying to get a level playing field for each constituency amongst the candidates. My lady, it's 2 minutes to my allotted time. I hope that doesn't cause any difficulty unless I'm reminded of anything from my right, or the court would wish to embark upon any questions.
We are never unhappy if council take slightly less time, or even a lot less time.
Well, I've kept a
than they
close eye.
intended for.
I kept a close eye on my watch,
Yes.
my lady, and 2 minutes before, I don't take up 2 minutes for the sake of taking up 2 minutes.
Thank you, Mr. Stoker. I think we have no further questions for you. Mr. McGuinness? So now, Mr. Gordon.
My lady and my lords, we have 5 essential submissions. Can I state them first and then develop them briefly? First of all, we respectfully submit that the provisions in relation to what I'll call notional spending in Papera, by which I include the provisions on notional spending introduced into the Representation of the People Act by Papera, are there for obvious anti-avoidance reasons, and I believe that is probably common ground. Secondly, notional spending is of a different character to actual expenditure, and the legislator has, consistently with that different character, treated it differently from actual expenditure, whether in relation to electoral expenses, this case, campaign expenditure, controlled expenditure, or referendum expenditure. Moreover, the statutory provisions relating to notional spending are formulated in a materially identical way to each other in each of these 4 areas. Again, this may not be in dispute, but it may be. Thirdly, the starting and finishing point in our respectful submission is the statutory language. That language makes clear that the relevant deeming provisions in each class of case involving notional spending are there to define what expenses are to be treated as part of the definition of expenses incurred, a point made just now by my learned friend, Mr. Straker. The deeming provisions make clear that authorization is not needed, we say, for notional expenses to have been incurred. It's what the statute actually says. But for the deeming provisions, only expenses actually incurred by the candidate or his election agent or authorized by them to be incurred would be expenses incurred. The use of the deeming provision treats the notional expenses as being incurred, whether authorized or not. The 4th submission that we make is that both the respondent's case and the judgment of the Court of Appeal are founded upon an asserted overriding concept that is simply not there. By an asserted overriding concept, I mean an asserted overriding statutory concept that is simply not there, that of the supposed universal need for authorization. The concept of authorization has, we say, been elevated by the respondents and by the Court of Appeal from one that applies in part to actual expenditure into one that infuses the statutory regime as a whole. It does not. And the last submission that we make is that, properly analysed, our interpretation does not have the unreasonable consequences suggested by the respondents or by the Court of Appeal. May I also, although it hasn't yet been mentioned, to get them out of the way, make two threshold points. It is suggested by the respondents that a concession was made below, see paragraph 6 of their case. If such a concession was made, we say it can't affect the proper analysis of the statutory provisions in this case. Secondly, some points are made as to statements made in different documents by the Electoral Commission. As to those, we say respectfully, however much we would like to spend time analysing the statements of the Electoral Commission, again, they are not relevant to the way in which this court should interpret the statutory provisions. We do say, seen as a whole, actually, that the Electoral Commission guidance is correct. So may I deal with these points very quickly, because if they're right, we do say respectfully they answer the case. May I say, when I talk about the case, I mean the certified question, which you will find at page 116 of the core bundle. That does not, as we read it, talk in any way about made use of. It's not a question directed to use, and a lot of questions have been put to my learned friend Mr. Straker about what is meant by or on behalf of. Whatever by or on behalf of means, we say two things. First of all, it's self-evidently a question of fact. Secondly, it can't be solely dependent on the question of authorization. And thirdly, even if it were, contrary to those submissions, dependent upon the concept of authorization, it certainly doesn't arise from anything to do with the relationship between section 90C and 90ZA. And it is clear from the terms of the certified question, and indeed the judgment of the Court of Appeal, that it was those statutory provisions that it was looking at. So let me turn, as I say, to each of those 5 points. The first point, the anti-avoidance nature of notional spending provisions. And to state the obvious, notional spending is not called that in all the provisions, but notional spending is not actual spending. In broad terms, it represents the difference in value between the commercial rate for an item or a service and the price, if any, paid for that item or service of which use has been made. But for the deeming provision, of course, it's not spending at all. It is rather saved expenditure. Parliament, for obvious policy reasons, we respectfully submit, treat it as spending by, in the case of election expenses, the candidate. If it wasn't treated as spending by the candidate, it would be all too easy for the candidate to circumvent the election spending limits by accepting the benefit of gifts rather than spending anything himself. Without the deemed expenditure provisions, the candidate could incur zero expenditure but rely on others to fund his campaign through gifts. Use is the test that makes sense if the candidate has received relevant gifts, which led to avoiding having to authorize the spending of money. Questions of authorization are analytically redundant. So first of all, our first point about the irrelevance of authorization stems simply from the nature of notional spending. The second reason why authorization doesn't come into it, and this is my point too, is that notional expenses are treated in the statute differently from actual expenditure. It may not be completely obvious because the terminology is not always the same, that notional expenses is a concept that has consistently been provided for throughout the legislation by reference to the 4 general classes of expenditure, which are election expenses, campaign expenses, controlled expenditure, or referendum expenses. And if I can just go through this very quickly, giving the court references to the absolutely similar treatment, and I think it is again common ground because it's a point made by Miss Montgomery in her case in relation to some of these. Taking election expenses first, that is defined in the Representation of the People Act, section 90ZA1, Authority Bundle 1, tab 1, memory stick page 445. It doesn't use these words, but with the authority of is the substantive concept, again still on election expenses. The Representation of the People Act, Section 90 ZA4, Authority Bundle 1, Memory Stick, page 445. And notional spending in relation to election expenses, Representation of the People Act, Section 90C, Authority Bundle 1, Memory Stick, pages 446 to 447. If we move to campaign expenditure, that is defined in Pepera, Section 72, Authority Bundle 1, tab 4, Memory Stick, page 525. The concept of with the authority of is in Pepera in relation to campaign expenditure, Section 75, 1, Authority Bundle 1, tab 4, Memory Stick, page 531. And in relation to notional spending for campaign expenditure, we find it in Pepera Section 73, Authority Bundle 1, tab 4, Memory Stick, pages 528 to 529.
Could you give those as those on a piece of paper? You went through?
I could, Margaret. It may be easier for the court. We can certainly do that afterwards. I've got them in a table, so very easy to reproduce. And if I can just give, for those of you who are actually being able to note, that we find the same references for controlled expenditure and for referendum expenses. I'll give them briefly, but we will hand this up in tabular form. Controlled expenditure defined in Pepera, Section 85, subsection 2, Authority Bundle 1, tab 4, Memory Stick, pages 542 to 543. The authorization provision in relation to controlled expenditure, Pepera, Section 90, subsection 1, Authority Bundle 1, tab 4, Memory Stick, page 555. And finally, in relation to notional expenses, which it is called, I think, in this section, Pepera, Section 86, Authority Bundle 1, tab 4, Memory Stick, pages 546 to 547. And finally, in relation to referendum expenses, Pepera, Section 111, subsection 2 for the definition, Authority Bundle 1, tab 4, Memory Stick, page 592, for the authorization provision, the general authorization provision, Pepera Section 113, subsection 1, Authority Bundle 1, tab 4, Memory Stick, page 595. And finally, in relation to notional expenses for referendum expenses, Pepera Section 112, Authority Bundle 1, tab 4, Memory Stick, pages 593 to 594. And what we say about that, when you look at it, is that the separate treatment of notional spending in each of the different classes of expenditure in the legislation is necessary precisely because notional spending cannot, for the reasons I have explained, be shoehorned into the language of authorization. And what we say is that the respondents fail to grapple with the discrete effect of the notional spending provisions as opposed to the provisions relating to actual expenditure. So, for example, when addressing campaign expenditure in their case, at paragraph 32, see Memory Stick, page 91, the respondents mistakenly assert that, quote, expenditure becomes campaign expenditure because it is authorized. Section 75.1 of Pepera, this is still quoting from their case, provides that campaign expenditure cannot be incurred without the authorization of the treasurer of the party. And this is to ignore the effect of the discrete notional spending provisions where campaign expenditure is treated as incurred by virtue of 73 subsection 2, independently of section 75 subsection 1. So that is my second point. And if I just summarize where I've got to, I say, first of all, the nature of notional spending defies attributing to it a concept of authorization. Secondly, we say, in terms of the structure of the legislation, it is incompatible with the notion of authorization. And thirdly, the statutory language. This is my point 3. And we say that it is not only the nature of notional spending and the statutory structure within which that concept is bounded that make it clear that authorization is immaterial to whether spending in the relevant category has been incurred. It follows inevitably, we say, from the statutory language. And we say that for 4 very simple reasons. First of all, the word authorized appears nowhere relevant in the applicable statutory provisions. The requirement of authorization does occur, or does appear, I should say, in Section 90ZA4, as we know, but only as a method of legitimately incurring relevant expenses if they have not been incurred directly by the candidate or by his election agent. So the whole point of the deeming provision in 90C2A of the Representation of the People Act is that they are deemed to have been incurred by the candidate and not on his behalf. Second point, it is the fact of expenses being incurred by the candidate, or alternatively, if that had been the case on behalf of the candidate, that conditions the content of the return. The obligation to declare election expenses via a return is contained in Section 81 of the Representation of the People Act. See Authorities Bundle 1, Memory Stick, page 436. The effect in law of the deeming provision is that the expenses have been incurred by the candidate. Materially, therefore, it is entirely consistent for Section 81 to refer to the return being required to contain, and I quote, a statement of all election expenses incurred by the candidate. And Mr. Straker has correctly distinguished between the concept of incur and the concept of authorize. So in other words, Section 81(1)(a) picks up the language of the words incurred by the candidate. Third reason on language of the statute, as is clear from Section 90C1 of the Representation of the People Act, the section applies where property, goods, services, or facilities are transferred to or provided for the use or benefit of a candidate free of charge or at a discount. And it's important, and the further criteria in Section 90C1b are satisfied. Now, the deeming provision in 90C2a comes into play by reference to 1, the section having relevant application in the first place, and 2, the appropriate amount of election expenses being determined in accordance with the rest of the section. It follows that authorization has nothing to do with the section applying or being given effect to. The legislation is interested in utilization by or on behalf of the candidate. And the last point, the Representation of the People Act, Section 90ZA4, on which the Court of Appeal appears largely to have based its analysis, does not affect this result. Section 90ZA4 is entirely consistent with Section 90C for the following reasons. First of all, the purpose of Section 90ZA4 is to clarify what is meant by the phrase incurred by or on behalf of a candidate, which appears throughout Part 2 of the Representation of the People Act. Secondly, the deeming provision in Section 90C2 tells the reader that certain expenses are deemed to be treated as incurred by the candidate. Section 90ZA4 does not detract from that. The effect of Section 90C2 is that such expenses fall within 90ZA4A. That is to say, they are incurred by the candidate. Accordingly, we say, point number 4, Section 90ZA4 is consistent with and does not detract from Section 90C. It slots in very tidily. Section 90C deems expenses to be incurred by the candidate, thus satisfying limb A of Section 90ZA4. So the respondents seem to submit, in answer to these, what we submit are very clear points, that we have focused only on the use aspect of Section 90C1b, see their case at paragraph 70. But that submission is wrong. Giving a candidate a benefit is not enough. The relevant remaining words in Section 90C1b are, quote, in circumstances such that, if any expenses were to be or are actually incurred, they would be or are election expenses incurred by or on behalf of the candidate. And we say those remaining words of Section 90C1b import the further features of the definition of election expenses in Section 90ZA1, in particular the words for the purposes of the candidate's election, which are in turn explained in Section 90ZA3. So these words are hardly otiose on our interpretation. So that is where we get to in our positive case. The nature of notional spending, the structure of the Act, and the statutory language. It remains on the certified question to analyse whether the respondents can possibly be correct in elevating authorisation as the centrepiece of their analysis. And as far as that is concerned, although they suggest that it is the key to resolving overlap, which is how they put it, that is misconceived. One of the several fallacies running through their case is to equate, as they must, consistent with the logic of their argument, incurring with authorizing. And this is the point briefly touched on by my learned friend Mr. Straker. Can I point to at least two parts of their case where they don't shrink from that elision? First of all, in their case at paragraph 13, they use the words, the respondent's case is that expenditure must be incurred, and then this illuminating parenthesis, i.e. authorized, i.e. authorized. Even more starkly in their case, at paragraph 21, see page 88 of the memory stick, the respondents go so far as to assert that, quote, to incur is synonymous with authorization. Now, one only has to look at those words in that sentence to see that it is plainly erroneous. And we say this is unpromising as the foundation stone of any attempted legal analysis. Not only do the words bear completely different meanings, but as we see a little later in their case, at paragraph 60, see page 96, the respondents there correctly use the words disjunctively rather than interchangeably. Moreover, and perhaps making the most obvious point...
Sorry, which paragraph was that?
It's paragraph 60, my lord.
60.
Memory stick, page 96. I think they use the words incur and authorized disjunctively. I haven't got it to hand, but it's...
No, I've got it.
Yeah. Moreover, and perhaps making the most obvious point, the notion that incurred means the same thing as authorized flies in the face of the deeming provisions running throughout the legislation. So in truth, we say, the respondent's suggested analysis is derived from nothing more than unsubstantiated assertions repeated in different ways for emphasis. They posit without any statutory or other source that might convert assertion into logic or principled argument. That, see their case at paragraph 5, memory stick page 83, they say that because the various categories of expenditure may overlap and not always be easy to separate cleanly, the legislation has included an overriding requirement of authorization before anything may be said to be incurred. They further assert, see paragraph 7, that our interpretation, quote, runs entirely contrary to the legislative use in both the Representation of the People Act and PEPERA of authorization as the mechanism for categorizing or attributing expenditure. And at paragraph 23, see memory stick page 89, they contend that unauthorized expenses are not election expenses and that a failure to declare unauthorized expenditure does not constitute a criminal offence under section 81. Now we say these individual, let alone taken together, submissions are all complete non sequiturs. There are many areas of electoral law, as well as many areas of administrative law, that involve uncertainty and where a degree of judgment may be required to arrive at which side of the line a particular question falls. And indeed, there has been, and my learned friend Mr. Straker foreshadowed this, there has been Electoral Commission guidance on the subject of splitting campaign expenditure. It's in Authorities Bundle 2, I'm not going to take you to it because of the limited time I have, but I'll read some of it. Tab 24, memory stick page 1034, and you may think this is obvious common sense. In all cases, you should make an honest assessment based on the facts of the proportion of the cost that can be fairly attributed, I want to emphasize those words, to your campaign spending. You should apply the guiding principle to all situations where you need to split campaign spending. This will be straightforward for many items, however, for some it will be more complicated. The examples in the next section will help you understand how you should approach your assessment. Now, that kind of assessment, familiar to anyone charged with giving effect to borderline legal questions, whether or not surfacing in electoral law, has nothing to do with the concept of authorization. The two are not logically linked or with respect linked in any other way. The submission, see the respondent's case at paragraphs 95 to 98, memory stick page 104, that apportionment is somehow legally impermissible because of the repeal of section 90B, which contained a duty to apportion in a prescribed way in certain circumstances, does not and cannot mean that there is no power to apportion. But more importantly, and this seems to us to be determinative of that particular submission, which Mr. Straker described as a correctly, I think, as a distraction, it is absolutely clear, if one thinks for a moment about this, that the terminology of the repealed Section 90B of the Representation of the People Act, for which see Authorities Bundle 1, Tab 2, page 477. Perhaps you would quickly look at that.
Sorry, reference again, please.
I'm sorry, my lord. It's Authorities Bundle 1, Tab 2, page 477. The reason I ask you to look at it is only to compare the language. And then if you could turn, because you will see that the core concept in that language is reasonably attributable, I think, in other words. So if you look then at section 90C, little Roman 3 to 4, Authorities Bundle 1, Tab 1, pages 446 to 447, you will see materially identical language.
What are we looking at?
So two things, my lord. First of all, the language of the repealed section 90B,
Yeah.
and that is at Authorities Bundle 1.
I've got it now.
Yeah. Now, what is said by Miss Montgomery and her team is that because that was repealed, that proves we can no longer rely on apportionment. So if you compare that language to sections that have definitely not been repealed and at the centre of this appeal, section 90C, little Roman 3 to little Roman 4, Authorities Bundle 1, Tab 1, pages 446 to 447, you see the language replicated. So there's absolutely not only a non-point, but it actually drives a coach and horses through the respondent's case, because
Sorry, which are you referring to? 90C?
I'm referring to 90C, little Roman 3 to 4. And I think,
Subsections 3 and 4.
yeah, you'll see the same language.
I see no little Roman 3 to 4.
Oh, well, I'll have to...
They're not little
Subset-
Romans, Mr. Gordon, they're subsections.
It's Arabic 3, I'm sorry, 90C 3, and then it's Roman little 3 to 4.
And,
Sorry,
and those are, as I understand the submission, that those are references to the need for apportionment in relation to what you've called notional spending.
Yes.
I understand that submission. We were told that 90B, while it existed, which we've got at 477, was designed principally for splitting expenditure which was attributable to simultaneous elections, as does the Commission's guidance at 1043 very largely refer to.
Absolutely. We don't shrink from that. The point we seek to confront, if confront is the right word, is that it's said that the repeal of that section, section 90B, is somehow relevant. And it isn't, because apportionment...
I understand that submission.
That's the submission, because the key to the respondent's case is you can't ever have a sensible borderline in these different categories of expenses without identifying the authorizer. That's what it comes to. And obviously in our submission, identifying the authorizer doesn't stop the anti-avoidance provision that notional spending involves, but apportionment is what has to happen. The respondents say, well, you're completely wrong about that because apportionment's gone. Well, it hasn't, is the simple point. And the respondents, we say, are driven into a further logical cul-de-sac in paragraph 30 of their case. See memory stick page 90. There it is argued that the same expenditure may qualify as campaign expenditure for which a party is responsible as well as being qualified. Brackets, telling brackets, subject to authorization, close brackets, to be treated as an election expense. This argument, misconceived as we respectfully submit it is, has to be made in order to justify the assertion that the legal borderline between campaign expenditure and election expenditure can only be located in the concept of authorization. That's what runs through their case. And it's demonstrably wrong. It's demonstrably wrong for two reasons. First, because the statutory definition of campaign expenditure in Papera is expressly made subject to subsection 7, and subsection 7 explains that campaign expenditure does not include anything which falls to be that in the return of the candidate. So that's what...
Montgomery's proposition, isn't it, that they're mutually exclusive?
Yes, absolutely.
You agree with that, do you?
We do, but the question isn't whether they're mutually exclusive. The question is what is the process for drawing the dividing line? And the answer to that is not Miss Montgomery's locate and identify the authorizer. Indeed, you can just see how the anti-avoidance provision would work if that were indeed the way of assessing the borderline. The way you do it is by apportionment. And we find a similarly flawed interposition, this subject to authorization, nowhere to be found in the legislation in the penultimate parenthetical phrase subject to authorization. So if you look at the final line of paragraph 35 of the respondent's case, memory stick page 91, it's always putting in brackets as if it somehow represented a mantra which was elementary, that everything was subject to authorization. Well, it plainly is not in our respectful submission. So if the respondent's case fails, as we say it must, and I'm conscious that I have only 3 minutes left, in its reliance on authorization as the supposed legislative panacea, the respondents have actually offered no analysis whatever to counter that of the appellant. And so can I just very briefly, in the time left, say the last point, there are no unreasonable consequences flowing from our interpretation. Essentially, it's a very simple point to make. The first point made by the respondents, and I think by the Court of Appeal, was that we're in peril of committing criminal offences, if we're right. Well, we say that's not correct. They say that, I should say, in paragraphs 19.3 and 28 of their case. See memory stick pages 87 and 90, and then the fuller submission recorded in paragraph 24 of the Court of Appeal judgment at memory stick page 128. Well, we say that there aren't any offences under 82.6 or 84 in reality, in substance. First of all, as regards section 82.6 of the Representation of the People Act, see Authorities Bundle 1, memory stick page 441, the mens rea is knowingly and making the declaration falsely. And so the nub of the offence is plainly the declaration of an honest belief in the accuracy of a disclosure which is known to be incomplete or inaccurate. And so if the defendant honestly believes that his declaration is accurate as a result of ignorance or anything else, the elements of the mens rea will not be made out.
Well, does that operate if his mistake is one of law?
Well, I had no idea somebody was acting, an innocent bystander was acting. Therefore, I had no reason to suppose that I had entered a false declaration. If you look, I won't take you to it now, but if I could invite you to look at the case of Jones and Witcher, which is in the memory stick page 901, and look at page 259D, you will actually see, I think, that Lord Bingham, then Lord Chief Justice, described the offence in terms of dishonesty. So we certainly say you have to have mens rea for that offence. Now, as regards the separate offence under section 84, that section, and section 84 of the Representation of the People Act, is to be found at Authorities Bundle 1, tab 1, page 442. That's expressly made subject to section 86. See the same bundle and tab, memory stick page 442 to 443, which sets out excuses, including provision in section 86, subsection 3, little d, for an application for relief on the ground that the failure, error, or false statement arose by reason of inadvertence or any reasonable cause of a like nature. And we note that since the original submissions were made to and implicitly accepted by the Court of Appeal, i.e. that the offence was one of strict liability, the respondents have acknowledged the excuses set out in section 86, and we can see that they set those out in their case at paragraph 28, memory stick, page 90. And so we say that in substance, there is no question of the filling in of a return being prosecuted, let alone prosecuted successfully. Now, there is a further point which I'm not going to have time to deal with, but can I just indicate what it is? The respondents contend in their case at paragraphs 81 to 82 that the goods, services, or facilities referred to in section 90C might, on our interpretation, be used on behalf of a candidate without his or her knowledge or consent. And to similar effect, the Court of Appeal made a reference to obvious difficulties, the same point. And a related third point made at paragraphs 86 to 87 of their case, that is that third-party expenditure of £700 is permitted without the need to report it, where on our construction it would have to be reported. As to those points, we say they do not have merit. What matters is whether the property, goods, services or facilities were used by or on behalf of the candidate. A candidate will know if he's made use of it himself. He could choose not to do so. He could disclaim. A well-wisher acting wholly independently, and that will be a question of fact, and I know that's been a lot of the ground explored with Mr. Straker, but a well-wisher acting wholly independently of the candidate, or in circumstances where the candidate has disclaimed, will by definition not be making use of by or on behalf of the candidate. He would not have the candidate's authority to do so. It would come down to a question of fact, always, as to whether the third party was acting in some way, in a way that would render the candidate responsible. Can I just use the phrase, because it's not synonymous with authorization, turning a blind eye? If the candidate turns a blind eye to what's going on, it's right that he would be caught by the notional expenses provision. Yes, if he's turning a blind eye, he will be caught. But if a person is acting wholly independently of the candidate, then that person is rightly caught, we say, by the statutory regime under Section 75. And you explored that with my learned friend, Mr. Straker, and I won't go into further detail on that. So we say, overall, and finally I should mention there are further points made by the respondents about donations, referendum expenses. We've only got a day, I've only got half an hour, but
You've had your half hour, Mr.
And I've had it, so there you are. My lady, those are...
In fact, you've had rather more, because Mr. Straker finished early.
Well, Mr. Straker is always very kind to me, thank you.
Thank you, Mr. Gordon. Thank you. Now, who's going first for the respondent?
My lady, I am. Firstly, we accept Mr. Gordon's suggestion, contrary to that put forward by Mr. Straker, that you do need to construe the Representation of the People Act, particularly these sections which were introduced by the Political Parties Act, PEPERA. There seems to be a competition as to which it's going to be called. But in any event, the sections you're concerned with were introduced by the Political Parties Act at the same time as, again, as Mr. Gordon acknowledges, near identical provisions were introduced in relation to the other categories of spending: party spending, campaign spending, third-party spending, and also referendum spending. What is also significant is that each of those schemes also share the same characteristics as the Representation of the People schemes, that there are prohibitions on incurring expenses other than through the responsible person or the treasurer or the agent. The name changes, but there's always someone who is the only person who can incur expenses, and there is always a prohibition on paying anything unless you're the named person. And the reason why we suggest it's relevant to look at all that in the context of very specific limits that then exist for the various categories of spending is to test whether it would be sensible to have a rule that deems something to have been incurred by the responsible person when they've done nothing that might be equivalent to incurring. Now, we've used the term authorization, but it'll be some cognate term that has in it the idea of accepting legal responsibility for something. But if that's right, that by using something where that use is potentially by an agent at some distance from the responsible person, then we would submit you get into all sorts of difficulties, because by that use, you then have a situation where you treat the payment, because it will then be deemed to be election expenses in the case of the Representation of the People Act. If it's been paid for by the party but deemed to be an election expense, you've committed the payment offence. If it's been incurred by somebody without authority, you've potentially committed the incurring offence. But worse still, you've shifted the amount that the person who's paid for it is entitled to pay and incur under the scheme. The party can pay for amounts on its own volition, you've shifted that amount from their budget to the candidate's budget. Because again, as Mr. Gordon says correctly, where you get spending that is potentially party campaign expenditure or potentially election expenses, then it's all treated as election expenses. And the same is true for third-party campaigning. Again, if there's expenditure which could be any one of the three, it defaults down to election expenses on the part of the candidate. Now the reason that it is relevant to look at that is we say the effect of that will be that where the party pays for something it's entitled to pay for, which incidentally is of benefit to the candidate, and one of the candidate's agents says, did you see the party election broadcast, wasn't it splendid? Or did you see the party brochure? Or did you see the Prime Minister when they came here? As soon as that happens, as soon as there's something that might amount to use on behalf of the candidate by, for example, one of his more remote agents, the party commits the offences of having paid for it because they paid for election expenses, and the budgetary result is that you get a shifting of the liability to account from the party to the candidate. Now, that may be answered by Mr. Straker's point. Well, you know, you can actually just look at the facts. Well, let's look at the facts. Let's look at South Thanet. Not at the particular party which is the subject of this prosecution, but the UK Independence Party. South Thanet was the base of the party. Its leader was a prominent promoter of the party, but he was also himself a candidate in South Thanet. So let's take UKIP expenditure in South Thanet. How are we to say how much of that expenditure is to be treated as notionally that of the individual candidate, Mr. Farage, and how are we to say which of that expenditure should properly be accounted for by the party? Because I would hazard a guess that that expenditure was certainly of benefit to him and that he will have, in some way, either himself or through people acting on his behalf, used it, relied upon it, deployed it. In which case, we find that the idea that 90C is a deeming provision for the purpose of saying that expenditure was incurred by Mr. Farage as the candidate is just a recipe for disaster. And it's made worse than that, because as we'll see, and it's going to be probably after the break now, there are particular points in the Act, particularly the Political Parties Act, where common participation is dealt with by very specific deeming provisions. My Lord Hughes has already remarked that you don't get your £700 if you're part of a common plan, so you don't qualify as an individual supporter for the purpose of election expenses. But when one gets to third-party interest groups, there are very specific deeming provisions where third parties have banded together either as part of a common plan or where the third party is in fact targeting its expenditure on behalf of a particular party. So we'll look at that in a moment, but the gist of it is this, that where you have two third parties banding together to campaign on a certain issue, there is a specific deeming provision which says all of the spending there should be taken on the account of the third party that's registered, if one is. So it would just be meaningless in the face of the notional expenditure provision, and the more so in relation to targeted expenditure by third parties. So we're talking about union expenditure which is targeted as supporting a party. Again, that is deemed to be expenditure by the party in certain circumstances and not in others. And the same problem is inherent in referendum, that again, there are specific deeming provisions which deem referendum expenditure to be incurred. Because as you'll appreciate, and I put in the recent EU legislation, and it may be a matter of public controversy in due course, but what the provision that's made in relation to that referendum was to say, where you are a permitted participant, but you are acting in common with another permitted participant, and in particular one that's been recognised and therefore received public funding, if it's part of a common plan that you're spending the money, that expenditure is deemed to be the expenditure of the regulated Section 108 participant, not yours. So the difficulty with the approach by the appellants and by the Electoral Commission to construing 90C in isolation from its impact on the rest of the scheme relating to election and referendum spending is it creates, as the Court of Appeal rightly identified, unexpected criminalisation of things that shouldn't be crimes, parties who's suddenly been treated as having notionally supported the candidate and therefore paid unlawfully for election expenses. And it also decriminalises things that ought to be an offence. The person spending £701, I should say, or in support of the candidate because one of his agents happened to walk in and say, in the course of Mrs. Bowman's meeting, I think you should know my candidate supports changes in the abortion laws. So the request my Lord Mance made to have a table, it is quite important because you will see then that in each of these categories you're going to run into exactly the same problems that we submit will arise by the approach that's been taken by the appellants. And I need to make it plain, I am not saying that there isn't something that there isn't some work done by 90C. There is work done by 90C. What it does is it deems the value of the expenditure. And it's there, as the recommendation of the Neal Committee made plain, in order to ensure that where goods are supplied and undervalued, their true commercial value is nevertheless reflected in the election returns.
Would you find that a convenient moment?
Yeah, yes.
It's entirely up to you.
As long as you give me that 2 minutes back if I need it.
We'll definitely give you the 2 minutes back, Ms. Montgomery. We'll look forward to hearing from you further at 2 o'clock.
Certainly.